Welcome to Spotlight Television. I'm Damon Roberts. How can you protect your assets in such a complicated world? Well, between creditors, predators, and taxes, today's assets are at risk from more than just lawsuits. That's why it's important to protect your wealth. Joining me today are attorneys Howard Rosen and Patricia Donlevy Rosen. They are leaders in the field of asset protection. They serve clients across the United States and abroad, and they have extensive experience with offshore asset protection planning and related tax issues. And they are considered authorities on these subjects among their peers. Regarded as pioneers in the integration of complex protective trusts, over the last 40 years, they have authored a number of books, including Asset Protection, a Guide for Professionals, along with research materials and numerous publications that have been utilized by planning professionals and investors around the globe. Please welcome Howard Rosen and Patricia Donlevy Rosen. Guys, welcome to the show.
Thank you, Damon.
Thank you, Damon.
Well, it's great to have you. Howard, how would you define asset protection planning, and what makes your company in the space different from others?
We define asset protection planning as the arrangement of a client's financial affairs in such a way as to place their assets beyond the reach of future potential creditors, while at the same time the client continues to enjoy and benefit from their assets. We differ from other asset protection planners in many ways. Number one, we've been doing it longer than anyone else. We've had extensive experience, including actual litigation in the offshore jurisdiction where we established the trusts. We're available to our clients around the clock. They don't deal with associates, they deal with Patricia or me.
So Howard, let's talk about your typical client. Who is that typical client who's coming to you?
Typical client nowadays is a business person, an entrepreneur, someone who's sold a business. When I give talks on this subject, I always emphasize that when a business is sold, the seller, who usually would be our client, should protect the proceeds of the sale immediately, because almost always a year later, the buyer has run the business into the ground and wants some of that money back. But really, anybody with any wealth in our society has an invisible target on their back for a litigator.
Not only has wealth, but who has great earning potential or inheritance potential should set this up. So what they accumulate over time can be protected before there's a problem.
So Patricia, let's talk about real estate a little bit. Obviously, owning property is the dream of everybody who lives in the country, to own a house. But obviously, owning property comes with a lot of risk. One of the biggest lawsuits, obviously, is real estate, people going after your home. In your opinion, is there a tool, or what's the strongest legal tool for protecting real estate from creditors today?
Well, first of all, one needs an offshore asset protection trust as the base of any protection. And with real estate, we can't move it offshore to protect it unless you live in California and there's an earthquake and it falls into the ocean. So the only thing that we found that works is removing the value of the real estate. And we do that with a structure that we developed about 30-something years ago that has worked against the US government even, where we remove the value of property, and we do that by working with independent offshore lenders who will lend 95% of the client's available equity. So we find out what the property's worth, we get an appraisal, we subtract any mortgage that might be on the property, we see what's there sitting there for a creditor, we get the offshore lender involved. They make a loan of 95%. Those proceeds, though, must be put into the client's offshore asset protection trust. Just getting a mortgage on the property won't do it. If the client puts the money into their checking account, the creditor will be delighted that the money's a lot more accessible.
Is there a learning curve? This is an interesting question, because I think when people hear the word offshore, there's immediately some kind of stigmatism to, like, oh, what are we doing? Is there a learning curve in what you guys do, and either one of you can take this answer first, to make people feel comfortable with the idea of moving things offshore and what the legality of that is and how comfortable they can be with that? Is there a learning curve with clients?
I don't know if you would call it a learning curve, but there's a comfort curve, if you will. And the way I address that for a client, because they do ask these questions, the way I address that is I say, how would you select a doctor if you had to have a complicated life-threatening surgery, you would look for the one with the, the best credentials, that's, regarded as such by his peers, et cetera. That's your first security level, okay? The second security level, and that would be us as far as a lawyer goes. The second security level is, have we, as the law firm, have we done our due diligence on these offshore companies that we do business with, the offshore trustee company, the offshore financial institutions, et cetera? And the answer is, of course, yes. We have traveled to the offshore jurisdiction where we set up the trust 20 times in the last more than 3 decades that we've been actually setting up trusts offshore. So before we ever set up the very first trust there, we went there and did our due diligence on them. We've traveled around the world and met with the financial institutions where the trust will set up its financial accounts. We've done our due diligence there, and we relate that information to the client, and that gives them the comfort that they need.
How do you assure people that some offshore trustee that they don't know doesn't steal or run away with their money someday?
Good question. Okay, we're asked this all the time. First of all, like I've said, we vetted the trustees in person. The Cook Islands trust companies are more highly regulated by that government than our trust companies are, because that business to that little country is 11% of its gross national product. Having said that, there's more. There's another party, another offshore company involved. First of all, the trustee is a company. They sign documents with 2 of their employees each time. There's another company involved called a trust protector company located in a different country. The trustee company needs to get the prior written approval of the trust protector company before any money can go out of the trust. They don't know each other. They're in 2 different countries. Both of them sign with 2 different employees. So that's a check and balance that's built into every trust that we do.
You ask about the learning curve, and I know when we first got into this business in the early 90s, I had my law school friends calling me saying, "Donlevy, you were such a straight arrow. Why are you doing this slimy stuff?" Right? You say offshore, people get, oh, they're hiding assets. What we do, we are not hiding anything. There's nothing hidden. Once this structure is in place, actually, if a client gets sued, we say, tell your litigator to bring this to the other side. They'll see this is rock solid. They're not going to get anything, even if they get a judgment. We don't hide assets. We don't try to avoid paying taxes. A client is given a huge document to give to their CPA, so they file all the necessary forms, and so there's nothing shady going on. And we also tell the clients that we have done this ourselves and have been sued, and how it's worked for us when we were sued unfairly.
So we talked a little bit about taxes. Taxes are obviously a huge deal. Howard, you're a certified public accountant, I believe. Yes. Let's talk about taxes a little bit. What are the tax ramifications of an offshore asset protection program?
Actually, they're quite simple. The trust is referred to in a non-technical parlance as tax neutral. Okay, that means it does not save any income tax for the client, and it does not cost any income tax for the client. It does involve some information reporting to the government. But as Patricia mentioned, we provide the client with a detailed tax compliance document for their CPA so they know how to do this properly. So it's really tax neutral. The only tax savings, if you will, is that the typical asset protection trust will include conventional estate tax savings provisions that would be in any domestic trust that a general estate planning attorney would include.
And so is there a primary method you use to implement this type of tax planning? Is there one specific that you use?
The core of the planning that we do is always going to be an offshore asset protection trust. Okay, and that trust will include, as I just mentioned, it will include the typical estate planning provisions, such as continuing trusts for a surviving spouse, continuing trusts for children and grandchildren, those types of provisions. But it's much more than that, in that it has numerous protective provisions in it.
If someone wanted to open up an offshore trust to start to think about protecting assets, Is there a best country to do it from?
We've researched many countries over the years, but the Cook Islands is the only country where we currently set up offshore trusts. Number one, the Cook Islands was the first country on this planet to enact focused asset protection legislation back in 1984. The Cook Islands is a Commonwealth country, a British English Commonwealth country, same as Australia, same as Canada, and they became independent. They used to be part of New Zealand, like Puerto Rico is part of the United States, but they became independent in 1965, and they needed a way to generate some revenue for their country. So in 1984, they enacted the first focused asset protection trust law. Since then, 30 or more other countries have jumped on that bandwagon, but the Cook Islands has a track record which includes having thrown the U.S. government out of court twice. Because they don't get any aid, financial aid from the United States, they have no treaty with the United States which would require them to enforce a judgment of a U.S. court, which they will not do. And they have the most experienced trustee companies that we've ever dealt with, and I've always been a trust lawyer. So, and we've been there, like I said, 20 times in the last more than 3 decades that we've been doing this over there.
Can an offshore account and international financial instruments, can they help to guard against any of this, against the devaluation of the currency, against their purchasing power being taken away? What can we do there?
Well, I can tell you that the offshore trusts can invest in things that a U.S. person could not directly. You know, we here can invest in things the SEC has okayed. The offshore trust can invest in many instruments that aren't SEC approved, and
which doesn't mean they're not good investments.
Exactly. And the offshore trust, besides in different currencies, can invest in different currencies. And what it does, often the trustee, the money manager of the trust account will talk to the client, because we do have clients who say, I want all my money in gold. I want all my money in platinum. I want all my money in Swiss. I've got what Swiss is called. Swiss francs, or Swiss and Liechtenstein. So the answer is yes. A client has options with the use of the offshore asset protection trust that they might not have here. Some that they might, but many that they wouldn't have as a U.S. person trying to invest.
All right, guys, let's do the most important thing we can do. This has been a great conversation. Howard, if somebody is watching this and thinks, man, this is interesting, I really need to do more research, I want to look into it, I want to contact them, tell everybody how they can contact you, give them the website, give them the phone number. How do they get in touch?
The website is ProtectYou, all spelled out, protectyou.com. The phone number is 305-447-0061. Call the office. Our assistant, Angela, will set up a time for us to speak. We do not charge for an initial consultation.
Once somebody is our client, we don't charge to speak with them. We really want a client to keep the integrity of his or her structure. So we ask that before they do anything, buy anything, selling, they give us a call, run it by us so we can make sure they're doing the right thing for their protection.
Absolutely fascinating conversation, and we hope people will reach out to you, and thank you very much.
Thank you for having us.
Thank you, David.